Welcome everyone to today's webinar, OSHA Vaccine Mandate, Understanding the Obligations, Legal Challenges, and Best Practices. My name is Tawny Alvarez and I am a partner in Verril's Employment and Labor Practice Group. Thank you so much for joining us today to hear about this extremely important ETS and best practices moving forward. This presentation is being recorded. I would ask that people use the chat function in order to ask questions, and they should do so throughout the course of the presentation. And I will do my best to add in and respond to those questions as we are moving through the content. We have a lot to cover, which will be unsurprising to most of you who have been following the mandate. So we're going to jump right into it and get going. I always say that it makes the most amount of sense for us to have a complete understanding of where we're going and what we are going to talk about during the course of the next hour. So if we're going to outline what the next hour looks like, first we're going to talk about and better understand the legal challenges, where we are currently, what those legal challenges are, and what they mean for the rule moving forward. We're then going to have a discussion about what the rule provides, and throughout the course of that dialogue, we're also going to start busting some of the misconceptions and some of the misinformation that's out there about the rule itself. And then finally, we're going to talk about best practices for responding to the rule. I'm sure many of you are thinking, well, Tawny, the rule's been stayed. If we're going to understand the legal challenges, why don't we just stop there? Well, there is important things that we need to understand about how we move forward from here. But with that, let's first jump in and truly understand where we are right now. So the Fifth Circuit issued a decision at the beginning of this month, not last week, but the week before, which stayed the mandate itself. So we know OSHA issued the ETS on November 4th, with it going into effect on November 5th. We then had a host of lawsuits filed across the country. And the first decision that came out was from the Fifth Circuit in Louisiana. And what it did was it stayed the mandate. It said, we believe that the plaintiffs are going to be successful in finding that the ETS itself is overbroad, and accordingly, we are going to stay the implementation of the mandate. Now, this is a situation where the makeup of the court and why they chose the Fifth Circuit matters. So we're going to talk later in the presentation about whether or not judges have been appointed by a conservative or a more liberal president, and how that changes the makeup of the court, and why people are of the belief that having the current ETS before a more conservative panel makes sense. But first, let's talk about the Fifth Circuit decision itself and what it said, and in large part what it didn't say. So the Fifth Circuit decision, it's a 22-page decision, and it found that the ETS mandate is both over-inclusive and under-inclusive. And they say it tongue-in-cheek, kind of saying this is one of those rare occasions where we're going to say you screwed up on both ends. We say it's over-inclusive because not every workplace has COVID cases. And in order to implement an ETS, you're going to have to show across the board that you have an issue. In most situations when an ETS is issued, it's because of a chemical compound that employers are using that has an adverse effect on employees, where we need to have some type of safety regulations in place. In the current situation, while we know that COVID can be deadly, can be serious, it doesn't affect everyone in the same way. And we also know that it hasn't reared its head in every single workplace, which thus makes it over-inclusive. The court further noted, why are we treating an accounting firm the same way that we're treating a meatpacking plant? So over-inclusive in that it uses the same protections as to everyone. But it's also under-inclusive, because when I say everyone, we're really only talking about employers who have 100 or more employees. So why, the court says, is there any less of a risk to employers who have 98 or 97 employees? As a result, the mandate is both over-inclusive and under-inclusive, the Fifth Circuit says. The Fifth Circuit also spends time discussing the fact that an ETS cannot be used as a stopgap measure. And they do this in the same dialogue and conversation about the over-inclusive and under-inclusive nature of the ETS. In part, the ETS very specifically notes that they understand that while the purpose of the ETS is to protect unvaccinated employees, that were they to create individualized ETSs for every industry and for every size employer, it would be much too much work and they wouldn't be able to provide the protections that are necessary. So for now, they're going to create this. Now, we know that earlier in the year, earlier this summer, they created the healthcare ETS that was specifically set forth for healthcare entities. And there was a dialogue about whether different industries would see similar rules and regulations. Instead, we don't see that. We simply see this general ETS for employers with 100 or more employees. Additionally, the court goes into a dialogue concerning the fact that this ETS also flunks a cost-benefit analysis. The ETS has been estimated to result in $3 billion worth of compliance costs. And when that number is weighed against the number of unvaccinated individuals in workplaces who pose a threat to other individuals, the court felt as though it flunked the cost-benefit analysis. It's important to understand that in creating the ETS also, OSHA was very specific in stating that they were not attempting to protect all employees within an employer's organization. Instead, the focus of the ETS is only to protect unvaccinated individuals. So for employers who don't have any unvaccinated employees in their work environment, they still are required to comply with this OSHA mandate. But the reasoning behind why this ETS is attempting to protect them then doesn't make sense, and the cost-benefit analysis then has been outweighed. Additionally, the court, in passing, and I say in passing because it's at the end of the decision, they talk about some of the constitutional concerns. And it's important to understand that when courts issue an opinion, and this is kind of why we're spending so much time talking about the legal process and where we are right now, courts have a rule that they don't reach a constitutional issue unless they absolutely have to reach it. So if a court is able to determine an issue without reaching a constitutional question, they're going to get rid of the case without touching on the constitutional nature. In this situation, the court felt as though they could issue the stay without reaching the constitutional concerns. But in what's called dicta within the opinion itself, it does mention that even if a court were to disagree as to the ETS being over-inclusive, under-inclusive, a stopgap measure, all of these things that would foreclose the ability of OSHA to issue an ETS, it also has two constitutional issues, and one is the Commerce Clause. And the court says, a person's choice to remain unvaccinated and forgo regular testing is a non-economic activity. Now, we know that the federal government has its power to regulate individuals based off of the Commerce Clause, but if the action that's at issue is non-economic activity that isn't crossing state borders, then the Commerce Clause comes into effect and the federal government wouldn't have jurisdiction to issue a mandate. The other aspect is the police power. The police power of a state to provide for compulsory vaccinations. Now, throughout the course of the pandemic, we've been going back and we've been seeing multiple rulings, both in the history of the Supreme Court and more recently concerning limitations on gathering sizes and how that affects constitutional rights more generally. And the court has noted, and when I say the court, I'm talking about the United States Supreme Court, that the police power resides in the state, so that a state permissibly can make rules and ordinances in order to protect the individuals, even if those rules may violate other rights of its citizens. We see this a lot when we are talking about different organizations and their ability to limit gatherings, specifically saying that a church was unable to host 50 or more individuals, but Walmart could have 50 or more individuals. There, the Supreme Court said that there was too big of a burden on religious freedom, and therefore there was a violation of the First Amendment. So we need to understand that the police power lies within the state, but here we have a federal agency who is attempting to use police power to quote unquote protect the unvaccinated at each of the employers. So based off of all of this, the Fifth Circuit ultimately grants the stay pending review. So this is a temporary order that's issued. And it also orders OSHA to take no steps to implement or enforce the mandate until further court order. Now, I highlight this because I think most lawyers were really upset last week when news media came out and issues all these breaking news, breaking alerts. OSHA's indicating that it's taking no further action to implement or enforce the mandate. This was set forth in a 2-sentence statement placed on OSHA's website. That wasn't OSHA's choice. OSHA was following the court order that had been issued against it. If it had failed to do that, it would have been in violation of the court order. OSHA continues to maintain that this is a legal rule that's within their authority and that they should be taking steps to implement it. They will continue to argue about the appropriateness of the rule. So just because they're indicating that they're not going to take further steps to implement the rule doesn't mean that they're stepping down or they don't believe in the validity of the rule. So that's the Fifth Circuit challenge, but let's jump and let's talk about what's happening in the Sixth Circuit. So Fifth Circuit issues its ruling, but during this whole period of time, we have multiple people filing cases, all arguing that the OSHA mandate is unconstitutional, violates the authority that OSHA's been given, all these different arguments about why this ETS should not be maintained or implemented. What happens when something like that happens, where we have multiple lawsuits that are all making very similar arguments, is that they are all put together and placed into a multi-circuit lottery so that one court will issue all the opinions regarding those issues. So we don't have multiple circuits that are doing all this work to come to this on the same issue to potentially come to all kinds of different results. So on November 16th, a multi-circuit lottery occurred, and it resulted in the Sixth Circuit, quote unquote, winning the opportunity to review the legitimacy of OSHA's ETS. Now, the panel that will hear this issue is going to be made up of 3 judges. The Sixth Circuit is made up of 8 judges who are appointed by a liberal or a Democrat president, and 20 judges who were appointed by a Republican or a conservative president. So you see that the makeup of the Sixth Circuit is very similar to the makeup of the Fifth Circuit. 3 judges, however, random, will be chosen in order to hear and decide kind of this issue. The Sixth Circuit is made up of Michigan, Ohio, Kentucky, and Tennessee, and this case will be housed in the Cincinnati court. Just because it's in the Cincinnati court, however, doesn't mean that only judges from Ohio will be eligible to hear it. It could be 3 judges from Tennessee, even though the case itself is housed and filed in Cincinnati. So that is a general understanding as to where we're at right now concerning the legal challenges. The 3-judge panel has not been chosen. We don't know who the judges will be. Once we have that information, we may have a better sense as to whether or not, if they were appointed by a conservative president, if their leanings will be similar to the Fifth Circuit. The Fifth Circuit decision was made up of a panel of 3 judges, all of whom were appointed by Republican presidents, just to give a sense as to the leanings of the Fifth Circuit and where that decision came out. So that is where we're at right now from the legal challenges. I'm sure some people are scratching their head right now, though, and saying, well, Tawny, that's the focus from a federal perspective. Let's talk about state laws. How does state law play a role here? Every time you give a presentation, you're always talking about the fact that we can't just look at federal law. We also have to understand how state laws play a role. And we know that many states have implemented statutes that provide that an employer cannot mandate a vaccine. So how does that play a role in the current ETS standard? The ETS very specifically notes that it preempts state law as it applies to vaccine mandates and an employer's ability to mandate this type of behavior. It's important because this goes into some of the questions that we're seeing in the lawsuits that have been challenging the appropriateness of OSHA's ETS. Additionally, however, the ETS doesn't preempt all state laws. It only preempts state laws as they relate to COVID vaccinations. If a state law, however, provides additional protections to employees or additional things that employers need to do, then state law is going to continue to preempt ETS. And there's at least one situation concerning the ETS where that plays a big role, and it's concerning payment for COVID-19 testing. So here I am, we are 16 minutes into this presentation. I've done a whole host of talking about the law and interaction between the two of them, and you're likely scratching your head and saying, well, Tawny, why don't I jump off this, because I don't even know if my workforce is covered here. Does this apply to me? And that's really what I'm looking for here. Well, let's jump into who's covered, and then once we figure out who's covered, what is covered. So who's covered? It's organizations that have 100 employees or more, all levels, all locations, part-time and full-time, remote and in person. It's not like the FMLA where we're looking at different locations, and if they have 100 or more, they're covered, and 100 or less, they're not. No, the whole organization, all locations, all levels. Doesn't matter if you only work 1 hour a week or if you work 60 hours a week. We're looking at beating hearts here. Whether you're working at home and you never go into the office, or you're in the office all day, every day, 100 employees. The other important aspect of this is it's 100 employees at any point in time. I know before the mandate went into effect, we had a lot of clients who were calling and saying, should I just terminate a bunch of people now to get myself under 100? And our answer at that point was, we don't know if that's going to help, because we don't know if we're going to do a 6-month look back, as we do with many federal statutes, if we're going to be doing a looking forward, how it's going to be determined. Ultimately, what the ETS provides is that if at any point in time during which the ETS is in place, which normally an ETS will last for 6 months, so it'd be from November 5th for another 6 months, so we're looking till May. If at any time in that 6 months period you have 100 or more employees, the ETS is going to apply to you moving forward. So today, my employer has 96 employees. The ETS would not apply to them, right? So, or on, December 4th, the ETS isn't going to apply to them, even if it weren't stayed. But if on December 20th, I have 101 employees, it's going to start applying to me on December 20th. Then on the first of the year, however, 2 employees quit and I'm down to 99. The ETS is still applicable to my organization. It doesn't matter that I move below 100 employees. The moment I am at 100 employees or more, this ETS comes into effect. It's important for your operations team to know this as we move forward until we have a very specific definition, or we have a ruling from the Sixth Circuit as to whether or not this is going to be stayed indefinitely, if the ETS is overbroad, or if the ETS is found to be appropriate and within OSHA's purview. Now, some people might be saying, well, Tawny, is it the Sixth Circuit that's going to matter, or is it the United States Supreme Court? That's a great question. The most constitutional scholars believe that if the Sixth Circuit comes to the same decision as the Fifth Circuit, that the United States Supreme Court will refuse to review the decision. So they'll refuse certiorari. And the reason for that is that the only way in which the Supreme Court will hear a matter in most cases is if there is a disagreement in the circuits about how to implement or review a statute, or if there's a constitutional question. As I mentioned previously, the likelihood of getting to the constitutional question here is limited. Additionally, if the Sixth Circuit's decision is in line with the Fifth Circuit's decision, there wouldn't be a disagreement in the circuit, and therefore it would be unlikely that the Supreme Court would hear it. So if the Sixth Circuit says, nope, this is all within the bounds of OSHA, this ETS is permissible, then there would be a disagreement between the Fifth and Sixth Circuit, and we would likely see it go to the Supreme Court. If, however, the Sixth Circuit says, no, no, OSHA did not have authority to implement this ETS, it would likely end there, and the ETS would not go into effect. But keep that in mind when we're talking about how many employees you have, at least until May. Now, 100 employees does exclude independent contractors and staffing agency workers. So if you have 70 employees and you have 40 staffing agency workers, so you have 110 total workers, you're not covered by this, because those 40 staffing agency workers are covered by the staffing agency. And if they have 100 or more employees, then the ETS would apply to them, but it doesn't apply to you. So the workers are only counted as it relates to one employer. In this situation, that would be the staffing agency employer. Additionally, unionized workforces are covered by the ETS standards, so this does not affect the CBA that's been entered in, excuse me. The CBA is not overruled by the The ETS standard overrules the CBA, which creates other very interesting administrative law issues kind of more generally. So unionized workforces still have to comply with the ETS. Workforces that are covered by the Safer Federal Workforce Task Force COVID-19 Workplace Safety Guidance for Federal Contractors and Subcontractors are excluded. So if you are a federal contractor, the OSHA ETS does not apply to you, only the federal contractor rules apply to you. If you are an employer who's covered by the healthcare ETS, you are also excluded from the OSHA ETS. So keep that in mind as well. So that's who's covered and who's not covered under OSHA's ETS. Let's jump in and talk about what's required under the ETS itself. The first thing that is required that's kind of overarching in this whole entire situation is that the employer must have a policy on vaccinations, okay? You do not have to, and there is no place for you to submit your policy to OSHA. The only time you are going to have to show OSHA your policy is if you're audited or if a complaint is made and they contact you and request to see a copy of your policy. But otherwise, you're not submitting it as a log or anything like that. The policy on vaccinations is going to need to include a whole host of different things. It's going to have a requirement concerning COVID-19 vaccinations, or for those who are not vaccinated, rules and steps that are going to be taken in order to protect the employees. It's going to have applicable exclusions from the written policy itself. So that is going to be things such as medical contradictions. So if someone has a disability and can't be vaccinated, what you'll do in those situations. If somebody has been told that it's medically necessary for them to delay in receiving a vaccination, what you'll do in those situations. Reasonable accommodations for individuals who have a sincerely held religious belief. If there's no exclusion, however, then you need to include information on how we as an organization are going to determine an employee's vaccination status and how we're going to collect that information. We're going to talk about that very specifically in one of the slides in the future. We need to include how much paid time and sick leave will be provided for the purpose of vaccination. So not regarding people who get COVID, but time away from work up to 4 hours to be vaccinated, and that's going to be paid time. And then what leave is available in paid leave if somebody has an adverse reaction to the vaccination. Next, process for the employees in which they will notify employers of a positive COVID-19 test and how we'll then work to remove that individual from the workplace. There's a multitude of pieces of information in which notice is going to need to be provided to the employee, and we're going to talk about what specifically that information is. And then disciplinary action for employees who do not abide by the policy. So all of that information must be specifically included in your policy. For those of you who have not started creating a policy yet, I have a template. You are welcome to email me and I will provide that template to you. It goes through and it provides the multitude of different things that you're going to need, and as an organization figure out. You should use these slides to get a better sense as to parameters that are in place for your organization. Now you're likely thinking to yourself, wait a second, Tawny, it stayed. Why am I going to start working on the policy? It stayed, but in 2 weeks, right? These rules go into effect and it's unclear when the Sixth Circuit is going to rule. But a very strong argument can be made that if the Sixth Circuit were to rule, OSHA had all the authority to do this, these rules are in effect. The moment that the Sixth Circuit says that, these rules go back into effect, the stay ends, and therefore employers are in a position where they need to be in compliance with it. At the end of the presentation, we're going to talk about which of these elements you should be working on implementing now and which ones you should push off. But creating a policy is a really good one for you to figure out with your operations team so that you are in the best place moving forward to be in compliance with OSHA's policy if it is found to be enforceable. There is no language in the OSHA rules permitting individuals to not be vaccinated because of natural immunity. We know in Texas's rules that there's very specific reference to natural immunity or individuals who have had COVID within the last 6 months. Having COVID within the last 6 months is insufficient as it relates to being vaccinated in this situation. So somebody who believes they have natural immunity because of past COVID would be considered unimmunized and would still have to go through all the other parameters that other unimmunized individuals would. That is a little bit about policy on vaccination. So that's the first element of OSHA's ETS. Let's jump to the second element. And the second element is, how is the employer going to determine the status of employees as it relates to vaccinations? Now, I've talked to a lot of clients who already have started this process or already have all of the information. The big thing is, though, is whether or not their current process complies with the new OSHA standard. In a lot of situations, employers have told employees or collected information in which they've said, are you vaccinated? Yes or no. I attest that the above is true and correct. Under OSHA standard, however, we need documentation that proves the vaccination status of our employees. So there is accepted documentation. All of these documents are acceptable. And there's public websites for every state in which you operate in, where if an employee has lost their vaccination card, they can go to this website and they can begin the process to obtain a new vaccination card. If, however, the only time in which an attestation that says that an individual has been vaccinated without them showing you a card is sufficient, is if you have gone through and exhausted all these potential lists of ways to obtain acceptable documentation, and for some reason you're unable to do so, that's the only time in which we're going to be able to accept some type of attestation. A lot of employers have been saying, what liability or exposure do I have if I accept a fraudulent COVID vaccination record or COVID immunization document? None, if you as the employer have not facilitated the fraud. So you need to be careful, and if there's a document that you believe to be fraudulent because it has someone else's name on it, or it's completely different from all the other documents you've seen, you do have the obligation to not invite or facilitate fraud, but otherwise you're not going to be held liable for being provided with a false vaccination card. Additionally, however, you do have confidentiality obligations as it relates to the information you're going to be receiving under this OSHA standard. So you need to get a copy of the documentation, but those copies of those documents, that's all confidential information. So it's considered to be an employee medical record, and it must be maintained as such records are required to be maintained under OSHA standards, and it can't be disclosed except for a host of situations that we're going to discuss later in the ETS, because there is a disclosure provision in which an employee may be entitled to see all the documentation concerning their vaccination status and testing. So that is how we are going to go about determining vaccination status. The third element of the ETS is that we need to provide support for our employees and the vaccination process. So let's jump to that next slide. Support for employee vaccination. Employers are required to provide up to 4 hours of paid time off at the employee's regular rate of pay in order to receive the vaccination, whether it's the one shot of J&J or shots 1 and 2 of Moderna and Pfizer. If they get the 2-part test, that would be 8 hours, excuse me, of paid leave, because it's 4 hours per shot. You cannot require an employee to use personal or sick leave in order to receive the vaccination. So this time off is time above and beyond any time in which the individual may be provided under the terms of the employer policies. If an individual has an adverse reaction to the vaccination, you can require the use of paid sick leave to recover from the side effects. But if you as an employer don't have cut out sick leave, but instead you have, it's called PTO, and it's all together, right? You can require them to use the PTO, but if you have sick leave and vacation leave, and the individual has no sick leave remaining, you cannot require that vacation leave be used. So for employers who have one bucket, you can require that any time that's in that bucket be used for adverse side effects to COVID. If you are an employer that has multiple buckets, one that is PTO or sick leave and the other that's vacation, you can require that they use that PTO or sick leave if they have an adverse reaction, but you cannot require the use of vacation. So if they don't have any PTO or sick leave, you're going to have to provide them with additional time away from work to recover from the adverse reaction. You cannot require employees to use advanced sick leave, so you can't require them to go into the hole on sick leave. You must provide it in addition. You can set a cap on the amount of paid sick leave that will be provided to recover from the side effects, but the amount must be reasonable. Now, in pure government fashion, of course, they do not define what reasonable is, but in the discussion section, there is talk about up to 2 days. So 2 days would be a reasonable amount of time to permit off to recover from COVID symptoms. Now, we have a question that goes to the last slide that we just did concerning determination of vaccination status. And the question goes to the payroll company that the employer is using has created a module that tracks vaccination cards and testing. Besides the location business manager, the bookkeeper can also see the cards. They have to navigate to it, but it's still there. Is that an issue? If you're, it's a confidential document, just like any of your other medical records. A lot of individuals will use third-party providers to also manage their FMLA or short-term disability leave, where they would be acting as an agent to you to implement your FMLA or your short-term disability. Anytime that somebody outside of your organization has access to confidential employee data, there are additional risks. As long as you are making sure that there are sufficient protections in place, that the firewalls are up to date, that they are securing the information in a way that is better or more comprehensive than you would as well, then I see the risks as being minimal compared to the benefits that are provided from a cost standpoint. As to the bookkeeper being able to see the cards, so somebody who's outside of HR, I would ask that the organization, the payroll company, if there's a way that they can block access and limit access to that information only to people with the need to know, so the people who are in HR specifically, because the more people who have access, the more issues that you're always going to run into. So that is a little bit more about kind of how we go about determining status, and then also support for employee vaccinations, which is our third element. Let's jump to the fourth element, which is COVID testing for the unvaccinated. And this is where we see the most kind of dialogue and discussion in the news media. It does not apply to your remote workforce. So if you have unvaccinated employees who are working remotely, they are not going to be required to get tested weekly. If you have employees who are coming into work every day and they're unvaccinated, they're going to be required to take a weekly test, and for that test to be negative before they come into work. If an individual is primarily a remote employee, but they do come into the office, they are going to have to be tested. So if hypothetically, I'm a remote employee who works 3 weeks a month at home and 1 week a month in the office, within 7 days of me coming into the office, I have to have a negative screen and test that I give to the employer. If I come in once a week, every week, I'm still going to have to then have a weekly COVID test, and it's going to have to be negative. Isolation and face covering is insufficient. So very specifically, the ETS says it doesn't matter if the person's constantly wearing a face covering and never interacts with other people, they still need to be tested weekly for COVID. You can, however, use pool testing. For those of you who are not currently aware of kind of what pool testing is, that's when you're going to have a whole bunch of employees who are going to be swabbed. You're going to put it all together into one test. If it comes back negative, great. All of those people are negative, don't have COVID. If it comes back and says it's positive, all those people need to be re-swabbed again individually, and an individualized test needs to occur. Some employers are choosing to do this to cut down on costs, because if you only have to do one pool test, it's going to cost a lot less than doing individualized tests for everyone. If, however, and this is where it becomes interesting because the ETS itself contradicts. So if an employee has a prior positive, they can't be tested under a policy for the next 90 days. So if you have, if you test positive for COVID on November 1st, you're not going to be able to be tested until, so this is where my math isn't great, February 1st. So February 1st, around that point in time is when you'll be able to be tested again. But it says isolation and face coverings insufficient. In this situation, we would have to state that we're making an accommodation and that they're able to be at work without testing. They're still going to have face covering, but that the testing mandate isn't going to occur. We have to maintain records of each test result in the employee's medical records. So if we go back to that question that was asked about the payroll provider who is going to keep copies of vaccination records, it's going to have to be able to hold test results as well. So in speaking to your payroll provider, talk to them about, is that what the plan is, that they're going to hold the whole medical record, or is it the expectation that just that card is going to be included and you're going to maintain all the other information? If it's the latter, that means you have information in multiple different locations and can become confusing. It can become confusing in a multitude of different ways. For our employees who, when we're supporting the vaccinations, so when somebody is out on leave, let's say they get the COVID vaccine, they have an adverse reaction and they're out of work for more than 2 days, we know that under our policy, we're going to have to pay for the 2 days under the ETS. If they, however, are out of work for longer than that, you're going to want to make a workers' comp claim because you're mandated to have the individuals vaccinated within the workforce. And best practice is going to be to let your workers' comp provider know and let them determine whether or not that is a workplace injury. So keep that in mind if you have employees who have adverse reactions and are out of work for over 2 days. For when we're talking about payment, so we know that to be vaccinated right now, it's still free. So your employees are going to go, they're going to get vaccinated, it's going to be free. But for testing, in a lot of places, it's no longer free. So under the ETS says that an employee can be required to pay for the costs associated with COVID testing. Under Maine law, however, the employer is required to pay based off of the health screening or the health testing policy under Maine law, which provides that if the test is required pursuant to job duties and requirements, then the employer needs to pay for it. In this situation, the COVID test is required as part of the employment, and therefore the costs associated would be placed on the employer. So now you're thinking, well, wait a second, does that mean that I have to go out and buy tests? And if so, what tests should I be buying? It's really important to understand what constitutes a COVID-19 test. And this slide sets forth the requirements. The most important element that I want to draw your attention to is number 3. The test cannot be both self-administered and self-read unless it's observed by the employer and authorized telehealth proctor. So if you have a health plan or you have an employee assistance program where there's authorized telehealth proctors who can review it and then authorize or indicate to the employer what the test results are, that's great. If not, there's a couple of ways that it could be observed by the employer. One would be to do it remotely. There's no rule that says that it can't be done remotely with an employee swabbing themselves at home with the parties, the employer and the employee being on Zoom and watching it, as long as they're watching to make sure that the same swab is the one that we read the results of. The other way to go about doing it would be to have the employees come in early and swab on site and us to review the results. In either situation, however, a strong argument can be made that they are swabbing pursuant to their job duties and responsibilities, and that's compensable time. We know it's going to take at least 15 minutes for the results to come in, so that's 15 minutes a week. Some courts might hold that to be de minimis and not require payment, but I think it would be a high-risk decision for you not to compensate for that time. Now, let's go on to the next element, which is in your policy, you're going to have information which provides notification of positive test results and removal. So what happens if an employee tests positive? If we go to that next slide, so slide 14, the employees who test positive must promptly notify their employer, and that's going to be as soon as practicable, but before the scheduled start of shift or return to work. So that information, that requirement has to be included in your policy. Then the employer must make sure that employees who test positive remove the employee from the workplace. This is a physical removal. If the individual can telework or work remotely, they permissibly can continue to do that. The time away from work, if they test positive for COVID, is unpaid. So you don't have to pay them under the ETS. You can allow them to use vacation or sick leave, any paid leave they have, but you're not required to pay them under ETS. If there's a false positive, and then, so you have a positive screen and then the individual goes and receives a second test and that test becomes negative, really you're going to want to talk to a doctor about return to work in those situations. The type of test which is received, whether or not it's an antigen test or whichever one happens first, you're going to want to get a doctor involved to make sure that they are cleared to return to work. A pool test, if there is a positive test in a pool, you're using a pool testing remedy, you don't need to remove all of the individuals who are part of that pool. You need to do the individualized test to then determine who is positive under that pool. There's nothing regarding close contact. So there's no requirement that unvaccinated employees be removed if they've had close contact with somebody who has tested positive for COVID. Now, I know that a lot of policies continue to have that obligation. And remember that your rule can be more protective of employees than this rule is. There's additionally no requirement to do contact tracing if you have a positive screen. And there's no requirement that you maintain records under the ETS regarding people who are out of work because of COVID. But you may have other obligations under other statutes. So under the Americans with Disabilities Act, under the Family Medical Leave Act, and under the ETS, you may have obligations if you can show or it can be proved that the individual got COVID at work or it's related to work. I'm sure some of you are scratching your head right now saying, wait a second, no close contact, no contact tracing. This goes back to what the Fifth Circuit said about it being overbroad and under-inclusive. Kind of, we're seeing both elements here as to, wait a second, are we protecting employees? And if so, why isn't there any close contact or contact tracing requirements? The next element or requirement within the ETS is that unvaccinated employees wear face coverings. So face coverings is very specifically defined in the ETS. It has to completely cover the nose and mouth. It has to be made with 2 or more layers of breathable fabric that's tightly woven. It has to be secured to the head with ties, ear loops, or elastic bands that go behind the head. If a gaiter is worn, it has to be 2 layers of fabric and it must be folded to make 2 layers. It has to fit snugly over the nose, mouth, and chin with no large gaps on the outside. And it has to be a solid piece of material without slits, visible holes, valves, punctures, or other openings. So an employer can provide the face covering, but isn't required to provide it. You can have all of your employees, you can require that they all wear face coverings, but the mandate, the ETS, only applies to unvaccinated. There are a handful of exceptions as to when individuals do not have to wear the face covering if they're unvaccinated. One is when they're alone and they have floor to ceiling walls and closed doors. 2, the employee's eating or drinking. 3 for identification purposes, if you have security checks and they need to pull it down. 4th, if they have to wear a respirator or a face mask. Or 5, if the type of work that the individual is doing, a face covering would be infeasible or create a greater hazard. Additionally, it's important to understand that this requirement is not only when the individual is indoor within the workplace, it's also if the individual is traveling in a vehicle with other people on their way to, from, or doing work-related travel. They're going to have to be wearing this the face mask. If they're outside, then no face mask is required. So that's a face covering. Next, notice to employees. Employees are all going to have to be provided with specific documents and information. First, they have to be provided with the employer's COVID policy. They need to have, and we know the COVID policy is going to include the process in which the employer is going to undertake to determine the employee's vaccination status. Also, we need the leave and pay policies concerning how to obtain the vaccination and the side effects following vaccination, and how much time individuals permissibly can use if they have adverse side effects following the vaccination. We're also going to include in that notice, and it's in our COVID policy, the procedure to follow if an individual receives a positive COVID-19 test or diagnosis with COVID-19 by a healthcare provider. So timing on notice, who you need to notify, next steps, and what they can understand to occur after that. Next, the notice is going to include procedures for requesting records, and we're going to talk about what that looks like, but I push it to the end because this is the last thing I want you to consider or work towards when we're talking about the hierarchy of things you need to do right now. Procedure for requesting records should be at the bottom, because until the stay is lifted, there's not going to be any obligation or right to these records unless somebody is making a request for their personnel file under state law, and that's completely separate and apart from the ETS. Additionally, there is a document that the CDC has created called Key Things to Know About COVID-19 Vaccines. You need to provide that to all your employees. You'll also need to provide your employees with a document that's been created by OSHA concerning anti-retaliation rights and criminal penalties for the provision of false vaccination cards. Additionally, for your unvaccinated employees, you need to provide some additional information, and that's information on COVID-19 testing and the face covering requirements that you have in your COVID policy. So a lot of things that you're going to have to give your employees notice of. I suggest that you either put this online in a place that very easily can be accessed by your employees as soon as the ETS goes into effect, or that you at least start to collect and know how you're going to go about sharing this information with your employees. So we have 2 more obligations under the ETS, and we've got 7 minutes to talk about those 2 obligations, effective date and best practices. So reporting of fatalities and hospitalization. If the ETS does go into effect, right, if the stay is lifted and OSHA has approval to continue implementation, employers have to report work-related COVID-19 fatalities and inpatient hospitalizations. It doesn't apply to employees working remotely, and you're going to have to use, common sense, best practices in determining whether or not the COVID that the employee has garnered is work-related. Do you have a bubble of people who have all gotten COVID? Can the employee identify someone else they were in contact with who has also tested positive outside of work? If they can, and it's not work-related, you don't have any reporting obligation. If it's work-related, however, you're going to need to make a report to OSHA. How are you going to go about reporting fatalities and hospitalization? You're going to contact your OSHA area office. There's a toll-free number that you can use, or you can make an electronic submission at www.osha.gov. When you make that phone call or submission, you're going to need the business's name, the deceased or the hospitalized employee's name, time or location of exposure, what we've determined, a description of the incident, as it relates to when the exposure happened, the name and contact info for the employee's designated contact person. So that's what we're going to have to report to OSHA as it relates to work-related fatalities and hospitalizations. The final element of the ETS regarding record availability. So employees under the ETS are entitled to see two pieces of information or two kind of groups of information. One, they're entitled to see all of their own records. So a copy of their COVID-19 vaccination card, a copy of all their negative or positive COVID-19 screens, all of that information an employee is entitled to by the end of the next business day after it's been requested. The employee can also designate someone in writing to be its designee to receive that same information, but you're going to have an authorization or consent from that individual to receive the records. The other thing that employees are entitled to is two numbers. So they're entitled to the number of employees in the workplace, and they're entitled to the number of vaccinated employees in the workplace. So if your workplace has 240 employees and 216 of those employees are vaccinated, an employee who requests that data would be entitled to 240 employees, 216 vaccinated. No information about what departments, where they're located, anything like that. Just those two numbers is what they're entitled to. And that would be provided by the next business day after the request. Okay, 4 minutes left. We're going to jump into the effective date. So when, Tawny, does this all take effect? The requirements must be implemented on two different dates. December 6th is the vast majority, and January 4th, 2022 is the requirements for weekly testing. Now, right now, there's a stay in effect. So these dates are not applicable. But if the Sixth Circuit rules on December 5th that OSHA had the right to create this ETS, that it's within its jurisdiction, then on December 6th, it would all be implemented. All of these requirements would occur. You'd have the obligation to be in compliance with each of these rules and regulations. A lot of you are likely thinking, well, Tawny, won't OSHA extend it, knowing that, like, hey, we've all been sitting here waiting to see what the court is going to do. There's no obligation for OSHA to extend it. OSHA is continuously saying, we believe that we have the jurisdiction to do this. We wouldn't have done it otherwise. We believe that all of this is legitimate and necessary. But this brings us to best practices. So let's talk about best practices as it applies. One, we know the rule has not been overturned, right? Two, in addition to this ETS, we're going to go to slide 21. So best practices. In addition to this ETS, OSHA's general duty clause still applies. It still remains in effect. Now, you know that the general duties clause is what we've all been operating under since March of 2020, right? Some organizations have had higher standards or expectations under OSHA or CDC guidance, but otherwise, most of us have been operating under OSHA's general duty clause. We need to provide a safe and healthy work environment for our employees. The OSHA ETS standard can be argued that this is what OSHA expects for a safe and healthy work environment, which means that it's not unlikely that we may see employees who are using this as the expected standard and best practices to keep unvaccinated employees safe, and failure to do so could result in a whistleblower claim in which an employee is arguing, you're not keeping me safe, you're not abiding by OSHA's general duty clause, and after I reported what I believe to be best practices, you took adverse action against me for X, Y, and Z reason, or I refused to come in if you weren't instituting these practices, and when I failed to come in, you terminated me, OSHA retaliation. So keep in mind that what's reasonable for your organization should be compared to what the current obligations are set forth in the ETS standard. And you should talk with your operations team about costs associated with implementing different aspects of this and begin the process of applying some of these elements, or be in a position that you're easily going to be able to implement all aspects should the stay be lifted. There are steps that you should be taking to protect your interests, and I would start with a policy and getting information concerning vaccination status of your employees as being the two top priorities that you should be taking. If the stay is held to be appropriate, if the OSHA standard never goes into effect, you're still in a good place because now you have a policy, you understand what your workforce looks like. You haven't required anyone to be vaccinated. You've just updated your information concerning their status and have copies of the appropriate documents if anything were ever to happen. I thank you all for your attention. It's 1 o'clock. I apologize that, we ran right through everything. If you have questions, please reach out. Thank you again. Stay healthy and have a wonderful Thanksgiving with your loved ones. Thanks so much.